Apologize for the delay. Obviously, we've been on the floor for most of the day, so we're going to head and get this moving as fast as possible. Since I see Senator Young, we will call her bill first.
Thank you, Mr. Chair. For the record, Senator Karen Lewis Young from Frederick. I am here to briefly describe SB 116, Data Center Impact Analysis and Report. It is the cross-file of HB 270. The bills are not exactly in the same posture. The only difference is the House bill requires, as part of the study, a study on energy needs of data centers. The Senate bill eliminated that because of cost concerns. I happen to agree with the House bill. The energy analysis is critical to this. And having spoken to DLS, I am very confident that they can do the study of the economic analysis, the energy and environmental analysis within the scope of your fiscal note. So I hope you will be persistent in keeping the House language.
Well, Senator, that answers my only question. So that's exactly what I was going to ask you. To me, that's the most important part of this entire bill, was the energy analysis. So thank you very much. And while it was sent over in a unfamiliar fashion, I think we will send it back over the way it was meant to be. So thank you very much.
Thank you.
That concludes that bill hearing. The next bill hearing we have is Senator Muse.
Thank you, Mr. Chairman and members of the committee. I know you've had a long morning. We've all had a long day, so I will not hold you. And thank you for hearing this bill, Chairman Wilson and Vice Chair and members. For the record, I'm C. Anthony Muse, representing the 26th Legislative District of Prince George's County. And I'm here in support of Senate Bill 586, Corporations and Associations Methodist Church requirement to repeal, but to repeal with amendments, and that's what I really came to present today. Let me share the amendment and explain why it's relevant. After I explain it, I want to just create the background and say why it is relevant and why it's fair, based on conversations that I've had with people on both sides of this issue. The amendment allows the local United Methodist Church to disaffiliate from the United Methodist Conference and retain ownership of its property, subject to the previous to the provisions outlined in the amendments, so not just the appeal bill. For example, there was a lot of talk about what the United Methodist Church had invested in churches, et cetera. So this amendment then says, if a conference has made financial investments in the real property used by the congregation, the disaffiliating church must reimburse the conference for the total amount. It also allows the United Methodist Church to disaffiliate from the United Methodist Conference and retain, as I said, ownership of its property. Second, any payments made by the local church towards the acquisition, maintenance, or renovation of the property will be credited against the balance owed. And then thirdly, the United Methodist Conference must provide a full and transparent accounting of all its funds it has contributed to the acquisition or improvement of the real property before determining the final reimbursement amount. Now, as you all know, when this was passed into law around 1972, not long after Marvin Mandel, and I have a letter that's coming to you, but Marvin Mandel, who signed it into law, he came down and testified before this committee when it was Delegate Davis at that time, and said that that was one of the biggest mistakes he had ever made was signing that into law, because he knew himself that it was at that point a separation of church and state. And so that letter you all do have. I sent it to your emails. Now, here is what has not been discussed. We've been talking about the repeal. Here's what's not been discussed. Between 2019 and 2020, I'm sorry, yes. Yes, thank you. Between 2019 and 2023, at that time, the new book of discipline, or the 4 years, every 4 years, a general conference will meet, and when they meet, they make the laws for the entire Methodist Church. Between 2019 and 2023, those 4 years of the law for the church said that the churches would be allowed to leave. Nobody's talked about that. They would be allowed to disaffiliate. Therefore, the question at that time was no longer whether they would be allowed to leave, but rather under what processes they would be able to leave. Under the new law, they would be allowed to disaffiliate if they could pay a certain amount of money within a short amount of time. Here's some of the minimum requirements. If a local church desired to disaffiliate from the United Methodist Church, they had to be approved by the conference and the board of trustees. There was a standard form of disaffiliation that included, but was not limited to, the following: apportionments. They should pay apportionments up to 12 months and things like that. They said you can leave if you do these things. There were other stipulations, and too many to detail in this hearing. My point is, as I understand it, is that the moment the conference and the general conference allowed a church to leave by paying a required amount of money, the trust clause in effect should have read like this, or this is how they carried it out. All property is held in trust by the United Methodist Church unless the local congregation is able to raise the money to leave. That's really what it should have said, because that's what happened. But now, for smaller congregations, this amounted to large, unreasonable, burdensome amounts of money. Therefore, the conference's requirement, I'm now talking about the Methodist, about Baltimore, required forcing congregations to pay substantial fees in order to be allowed to disaffiliate with the conference. It placed small churches in an untenable position of having to either pay a significant portion of their resources to disaffiliate or remain in the denomination with which they no longer agreed. The new requirement also differed from the conference. It differed from conference to conference. If you know what I mean by conference, give me the two letters that I had. One conference said you can leave, and you can leave for free. And a conference is that geographical area that bishop is in charge of. Texas said you can leave for free. In Georgia, many of them left for free and were able to go with everything that they had. A lot of churches decided to leave. In Georgia, for example, a Cobb County judge ruled in favor of 190 local churches seeking to disaffiliate from the United Methodist Church. The Southwestern jurisdiction, a jurisdiction is a combination of a whole bunch of conferences with a whole bunch of bishops. They led the way, and I'll tell you why I'm saying this in a moment, with 37% of its churches disaffiliating. Some conferences were more heavily impacted. In Texas, churches could leave without paying anything at all, and about 25% of the churches left. They could leave, as I said before, without making any payments. Now, when in the Baltimore Conference, which also extended to the Eastern Shore, they called the Susquehanna Conference, they were able to leave for free. But when the new bishop arrived, the new bishop said of them, as it occurred here, you can leave for nothing, but then a few days later, they came back and said you can only leave if you pay half the cost or the worth of your building. Now, some of these buildings have been established for 100 or 200 years. Their worth may have been 4 or 5 million. And I have a couple of letters that I've sent to you that I'd like to share with, which is why many of the people behind me are here. They're here today because they were told, you can leave. So this was back before they closed the door to that, and I'll explain that in a moment, 2019 to 2023. But they made it impossible for them to leave. Here's one letter, and you'll have that in your packet from Nichols Bell United Methodist Church in Oldington, Maryland. The conference trustees sent us a bill for $2.5 million. We don't have that kind of money, which represents 35 times our annual mission share. We decided that if we even tried to raise that kind of money at that time, the congregation was unlikely to survive. We protested this policy, but were told that the Maryland trust law was firmly on the side of the conference, and they were not willing to even consider negotiating. Here's one other. This is Clark's United Methodist Church. They were, in essence, they were told that they had to pay half the cost of their building. So remember, under the original clause, you couldn't leave. Now they're saying you can leave. But they said that before they closed it because I guess so many were leaving. But keep this in mind, for this little church of 80 people, they went to them and they're here now, and they said you can leave, it's $1.5 million and you have a week to pay it. That is why my amendment is here today. That's why that's why we have the letters. So my amendment to this bill addresses this inequity, which almost assures that a church cannot leave, even though the Methodist Church said at that time, 2019 until 2023, oh, you can leave. But these burdens were not put on everybody across the state. As far as I'm concerned, it's unique to the Baltimore area, where the statute holds them, so to speak, to be in a church denomination that they choose not to be. And if we don't vote this out, it means we have agreed that we're going to let you be held hostage, because most of these churches are small membership churches. They're older members. They're 80 members or less, and the members are in their 60s and 70s. And when there were buildings like Mount Oak Church, they were willing to talk. When certain things don't happen and they close your church, they don't just take the church building. They take the pews, the organ, the piano, the dishes, the utensils, the church parsonage. There's something wrong with that in this day and time. One, you ought to be able to worship as you choose. So this amendment does not say that the Methodist Church is not owed anything. It says if they are owed anything, it's got to be paid off. But if they put nothing into the church, then you're able to leave. Because once again, even though the window was shut, they said you only have a certain amount of time to pay this money. The window was shut in 2023. My contention is, if a church could leave before and it was a matter of money, and the trust clause moved from the church is held in trust to, in reality, it's held in trust only if you pay the money. For that reason, I'm asking for this compromise. And it is a compromise. Everyone gets something. The clause remains that the United Methodist Church holds all things and, all property in trust. That stays there for those who want to stay. But then there's a comma and says, but for those who want to leave, if you pay your debts to the conference and your building is free of debt and not encumbered, you can leave. That's what I present before you, and hope that we can do this, which is the right thing to do, and it's the fair thing to do. Thank you, Mr. Chair, and I urge a favorable report.
Delegate Fisher.
Thank you. Thank you, Senator Muse. My question is, has the conference ever provided an actual accounting of what they put into the church in terms of canceled checks or any kind of proof of what they actually put in on any given church that wants to disaffiliate?
From all of my studies, no, they have not done that at all. They simply say, here's what you pay the worth of your building. Now, remember, in the general conference that sets the rules across the board, their stipulations for leaving were much more lenient. Pay 12 months of your monthly apportionments to the church, pay on the pension of the church. In this area, they said, and they've been pushing half of your building. So no, they've not, as to my knowledge, and as I've talked to other churches, they do not provide that at all. I'm sure if you asked for it, they would, but most of the churches that are represented here today, they never got a dime from the conference.
That's my understanding.
Not for anything.
That's my understanding
Not
as
for a
well.
furnace, not for a roof, not to build it, and yet they say either pay half of it or it's our building. That's, for me, that's not the way to do it.
That's my understanding as well. And I guess my other question is, it seems like the conference is perfectly happy with people just walking away, and then they get to own the property and maybe dispose of the property, sell it to someone else or what have you, and then keep the money, which clearly that's what this is about.
That's what they do. That's correct.
But I feel like the thing that the conference is missing, which is why I think they lack credibility, is that these churches have cemeteries.
Yeah, right.
And so they're asking the people who built the churches to walk away from their loved ones buried in the, is that what your experience has
That
been
they
as well?
can visit in so many ways, in an emotional way, every Sunday is what they've been doing. And by the way, if I didn't mention, I have an Attorney General's opinion that I've shared with you all that says, number one, it's perfectly constitutional. Number two, whether there are other lawsuits going on relative to what we're doing now, it is absolutely constitutional and right and has no bearing on any ongoing cases whatsoever. So we have that as well. And that's I have that here, and I'll share it with you as well.
Thank you, Senator.
I think we have shared it at your email.
Thank you, sir.
Thank you, Mr. Chairman. So one question that I brought up when Delegate Fisher introduced his version is if there was language about the trust in a deed, right? So like, as I understood from the folks that testified the last time, was that some of the properties include the language, some do not. So my question for you is that if this law were to pass where it basically gives an out for, I don't know, whoever wants to get out, so to speak, as long as they provide the accounting, the other requirements you have in here, would that supersede if the trust language was actually in the deed and recorded?
In the deed of the property that's owned by the church?
Yeah.
There are no Methodist properties where the deed is in the name of the Methodist church. Why?
No. I'm sorry. And I'll clarify, and I apologize. You're getting there, but so the name is in.
The name of that church.
Yes, but in the deed, it references the clause.
No, it does not. In many deeds, it's a straight out deed. Some of these deeds are 100, 200 years old. It has just been a known fact with this law that they put in place that your property is held in trust.
So just for clarifying, so if the deed does in fact name the clause in it, do you see an issue with this law somehow superseding and basically voiding that out of the deed? Does that make sense?
No, give me a scenario, help me with it.
Yeah, so like somebody wants to join the church. The building is transferred to the church, and at that conveyance, at the settlement table, they add the language of this trust in the deed forever. It's like in there. It's in the language, right?
In the deed, the original deed that dealt with ownership of the church.
Yeah.
That was not the case here. Remember, the United Methodist Church was just formed in 1972. 1972 is when it was Methodist Episcopal, Evangelical Brethren, and the Old Washington Conference. They came together and merged in 1972. Not long after, that clause was put in here. Most of those churches at that point were still 100 years old, 150 years old. Some of them who are here now still have their deeds. There's nothing in the deeds. The Methodist Church did not go back and say, give us your deed. We want to put this language in your deed. It was simply to be understood as a result of this clause that your property is held in trust for the Methodist Church, and whenever you cease being a Methodist church, we get all of the assets.
Okay. Okay, thank you. Senator.
Thank you, Mr. Chairman. Just one question. I heard you say that one congregation was given a week to pay back.
Clark's United Methodist Church, and they're here now.
But I don't see any, so your bill, I don't see anything in the reprint about that, so your bill doesn't address the time period for repayment?
That's something they can work out, because if you, let me say, for the most part, this is just a fact. What they've given any local church is a mere pittance of what they pay every year to the Methodist Church, and then it comes with interest, okay? So then, the way that would work, give me a scenario, say it again, the scenario in that.
So what happened in that, and I guess they're going to testify, but so what happens if they're given a week to repay and they can't repay in a week? Do they negotiate to extend the time or what?
By the way, let me say this. It is in the record from the attorney in the courts that this was the case. Most, as I said, 80%, and I'm put it this way, they owe nothing. They never paid for bills, never paid for a furnace, never paid for anything. And many of them either paid it back or through their monthly apportionments or yearly apportionments. You know, it's been paid back in many different ways. If there's something owed, they and their lawyers and others can work out how you're going to pay this $10,000 back. It's easy to pay $10,000 back, and I'm not saying that the conference does not deserve anything. They deserve whatever they put into it. But where churches have where they put nothing into a church, that does not become an issue, and they ought to just be able to leave.
All right, thank you.
You're welcome.
Thank you, Mr. Chair. Senator Muse, great to see you. Just a quick question. I know we heard earlier House Bill 1182 brought by Delegate Fisher.
Right.
And so I know this is in a cross file, so are there substantive differences between the two?
Not at all. For example, you can take his bill and just put my amendments on it and conform it, because both bills were the same initially.
Okay.
Both
So
bills
the
were the same.
You're adding.
To repeal indefinitely that provision. Once I put my amendment on, and want to accept that amendment, it just says unless, blah, blah, blah.
Right.
And so they can be conformed to be the same bill, and that could be the cross file. Yes.
All right. Thank you, Mr. Chairman.
Thank you. Thank you, Senator Muse. You said something that, that I did not know, and hopefully you can briefly and succinctly explain it to me.
Okay.
You mentioned that
I'm a preacher, so you know.
I know. I do know that.
I do my best.
I do. You mentioned that that the United Methodist Church was just established in 1972.
That's correct.
But then you said that some of the church buildings were over 100 years old. So what happened? How did they come, I guess, how did the congregations come to acquire those buildings? And is that what you're talking about with the deed and title?
No, there were three different denominations, so to speak, that merged in 72. The Evangelical Brethren, the Methodist Episcopal Church. Around that time in 1972, not many years one way or the other, they merged. When they merged, these congregations had buildings already. Most of those, and the congregations owned those buildings. It was once they merged at an annual conference where they go to make, or general conference, or in this case, annual conference, because I think out of 57 conferences, there are only 11 with this provision. 57 conferences with 57 bishops, only 11 with this property held in trust. So it was passed at an annual conference, And then they were sent down here to have what was in church law placed into statute, into state law. That's where the problem came in, and when everybody found out that our church is not
So the two
I'm
churches.
sorry, 68.
Okay, close enough.
Right.
The churches merged, and then they became the United Methodist
became
Church.
United Methodist.
And they just stayed in the buildings that they were in, under
of the
under the governance of the United Methodist
Correct.
Church. Thank you, that was what I needed.
I think that concludes all the questions, Senator. Thank you very much.
Thank you.
I'll move on to our last bill for the day. House Bill 431.
Is that my bill? I thought reparations was here.
You guys could kind of please keep it down. I appreciate your attendance, but we do have another bill hearing, so if you could move out quietly, I would really appreciate it. And thank you guys very much for coming.
Okay. Good afternoon, Chair Wilson, Vice Chair Crosby, and members of the House Economic Matters Committee. For the record, my name is Portia Wu. I'm Secretary of the Maryland Department of Labor. Thank you for having us back to discuss the Governor's Raise Act as amended by the Senate. We know registered apprenticeship will help grow our economy, attract businesses, and deliver family-sustaining careers to Marylanders. In fact, 93% of apprentices retain employment after completing an apprenticeship program, contributing to a high return on investment for workers, employers, and the state. That is why this is a key piece of the Governor's economic growth strategy. The RAISE Act focuses on expanding registered apprenticeship to new industries, employers, and communities. The changes proposed by this bill will break down barriers to the adoption of registered apprenticeship in new industries while maintaining high standards, quality, and transparency. The amended version of the RAISE Act before you today represents our collaboration with union partners, legislators, and employers. The changes establish a new advisory board, enhance tracking of program outcomes, and ensure timeliness and clarity for employers seeking to get apprenticeship programs approved. These changes will enhance accountability and effectiveness of these new investments. I'll touch quickly on what the bill does. I know you've had a long day. First, it creates a qualified intermediary program as a tool for scaling registered apprenticeships that provides plug-and-play frameworks and expertise as a bridge between employers, apprentices, and training providers, and helps us grow in non-traditional industries in particular. Second, it establishes a pay-per-apprentice program. We used to have an apprenticeship incentive program that sunset. While renamed, this still will provide small business grants to sponsors, including small businesses and employers, to offset apprenticeship startup costs. It also tackles the issues of ratios. It codifies the one-to-one ratio, but responds to the call for more flexibility, providing an expedited pathway for non-hazardous occupations. I do want to note there's a brief amendment in this section of the bill to clarify that the deviation from the one-to-one ratio can occur at the time of or following the registration of a program. Fourth, the RAISE Act establishes the Maryland Office of Registered Apprenticeship Development to focus on promoting apprenticeship to businesses. You will also see there's, fifth, an amendment to the bill to create the Registered Apprenticeship Development Advisory Board, comprised of legislators, labor leadership, and employers. This new board will advise the office on matters related to apprenticeship growth and strategy and program outcomes. And sixth, it repeals the Youth Apprenticeship Advisory Committee, as that role has concluded. I respectfully request a favorable report. Happy to answer any questions.
So any questions? Brad, you going to testify?
Just questions.
Gentlemen, just for information only?
Yeah.
I guess I do have a question with regards to the one-to-one ratio. I believe that was something that was of issue before. What was your resolution again?
So it codifies, generally speaking, a ratio of 1-to-1. but it provides an expedited pathway for non-hazardous occupations. So for example, if there are things that might involve worker safety and health, an elevated risk, or an elevated risk of public safety, so I know especially in the skilled building trades, this has come up as an issue, and we're very clear that we'll still maintain those safety standards in those occupations.
And was there an auto licensing structure for plumbers?
There was. We just struck the whole section based on
Okay.
concerns in the building trades.
Okay, good. I don't see any other questions on this bill. I think that concludes this panel. Do we have anybody else here to testify on the bill? I see we're missing some people. Just go ahead and approach, please.
Good evening, Mr. Chair, committee. For the record, my name is Ray Baker. I'm the Maryland Director of the Baltimore DC Building Trades, and I'm aiming to have the fastest testimony ever. We've worked with the administration on this bill. We support the bill with the amendments. We urge a favorable report.
You go. All right, seeing no further questions, that concludes this bill hearing. And seeing nobody else present and testifying for this bill, that concludes the bill hearings for the day. Colleagues, I know we have a long day again tomorrow, and we have 54 witnesses for bill hearings, so please, oh, and we're also going over, to my R's in the room, please pay attention, we're going over the energy bills tomorrow after bill hearings. Okay, so whatever you need, if you have any questions beforehand, if you need to see something beforehand, let us know. Okay? Thank you guys very much. Have a pleasant day.
How are you?